Hello, everyone, and welcome to Internet Law Review. For today's story, we are covering the most recent indictment against Julian Assange, the head of WikiLeaks. This is a criminal charge from the United States of America in the Eastern District of Virginia, where many of these national security cases are heard. And this particular round of indictments deals with conspiracy to receive and publication of classified information. Bradley Manning, otherwise known as Chelsea Manning, provided information to WikiLeaks of a classified nature, and WikiLeaks released that information, is the essential elements of this particular indictment. In a prior indictment, which is also ongoing at this time, Julian Assange was accused of hacking into government resources, conspiracy to hack into those resources, directing someone to access, or otherwise other elements of computer fraud and abuse. I think those charges are much less controversial. You cannot, as a reporter or anyone else, hack into a computer network, and you can't direct someone else to do so, and you can't assist them to do so. If that's true, I don't think that there's going to be much of a constitutional problem with those particular charges. These charges, however, are on a whole different world of pain when it comes to trying to figure out the First Amendment implications. And as they sometimes say, this one is above my pay grade. I know quite a lot about First Amendment law. It's one of my favorite topics, but this is high-level First Amendment law stuff. And if anyone on the internet in a chat room says they know the answer, they probably don't, because this is advanced con law that's even too advanced for my normal day-to-day stuff. So let's go through a brief background of how the United States has dealt with this kind of situation with classified information in the past, cover some related cases and situations, and discuss how this one might fall out. First, before we beat up on America too much over this, it's probably helpful to note that most countries have laws relating to classified information, publication of classified information, publication of secrets, and most of these laws, most legal scholars would agree, are much harsher than the United States in terms of what they cover, their penalties, and their scope. So there are official secret acts in other countries, most notably the United Kingdom, which I think most legal scholars would agree are much harsher than what the United States has to offer. So before we beat up on the United States too much, it's always helpful to have a little bit of context. So about the United States specifically, well, we have to start really early in our constitutional history with the Alien and Sedition Act, 1798. So this was a law that, as it says here, criminalized making false statements that were critical of the federal government. So this is obviously something that would not be considered valid today, but even in the early constitutional part of our republic, pretty much the exact same Congress that passed the First Amendment also passed a law saying that you can't make false statements that are critical of the federal government. So this is something that the United States has been dealing with for quite a long time. One of the most famous cases in this area is the case of Schenck v. United States, a unanimous decision from the United States Supreme Court in 1919, authored by none other than Oliver Wendell Holmes. You may have never heard of this particular case. You may not be familiar with the facts of this case, but I guarantee you have heard one of the most famous quotes of this particular case. So let's discuss a little bit about this case and that famous quote and see how it relates. So what happened in the Schenck case? Well, as you can see here, Schenck was a person who opposed World War I, and so he printed flyers that said that people should resist the draft. So basically, he produced a publication that said the draft is bad, and you should fight the draft. Okay. And for this publication, he was convicted of violating Section 3 of the Espionage Act of 1917, which is similar to the acts that are relevant to today's story with Julian Assange. So in this unanimous decision from the United States Supreme Court in 1919, the Supreme Court held that Schenck's criminal conviction was constitutional because, quote, when a nation is at war, many of the things that may be said in a time of peace are of such a hindrance to its effort that the utterance will not be endured so long as men fight, and no court could be regarding them as protected by the constitutional right. In other words, the court held the circumstances of wartime allow for greater restrictions on free speech than would be allowed during peacetime, if only because of the greater dangers present. So I told you that you've heard one of the most famous quotes from this case, even if you're not familiar with anything else from this case. And so what is that famous quote? Well, it's the famous quote about shouting fire in a crowded theater. This is where it comes from. Oliver Wendell Holmes writing, "The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing panic. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger." If you ever wonder where that phrase came from, it comes from this case as well. that they will bring about substantive evils that Congress has the right to prevent. It's a question of proximity and degree. So just to be clear, Oliver Wendell Holmes was using the example of fire in a crowded theater that would cause a panic of an example of speech that was so obviously unprotected as an analogy. This clearly isn't protected speech, and therefore this pamphlet is also not protected speech. If you think that analogy is a little bit weak, well, I don't know what to tell you. Oliver Wendell Holmes thought it was pretty good, and so did the rest of the United States Supreme Court. So when they said shouting on fire in a crowded theater is clearly unconstitutional, they also said that printing pamphlets telling people they should not sign up for the draft was also clearly constitutional in the exact same way. So that's where that phrase came from, that's how it's used, and that's the history of this case. So that case we just covered was from 1919, and obviously First Amendment law has moved along since then. The First Amendment law thesis has changed substantially, and it started changing right here in this case, Whitney v. California in 1927. Although in this case, the Supreme Court also upheld the conviction of a person who had engaged in speech, in this case by being a member of the Communist Party, which yes, was illegal, yes, was criminal, and yes, the Supreme Court upheld that conviction. If you're ever wondering why freedom of speech is good, or why we should have freedom of speech, I would just look at Justice Brandeis' opinion in Whitney v. California. It is to me the most eloquent, most simple, best explanation of freedom of speech ever written, ever. And the United States Supreme Court would formally overrule those decisions dealing with criminalization of freedom of speech some 40 years later in the case of Brandenburg versus Ohio. In this case, they took Justice Brandeis' concurrence and basically made it the majority opinion, overruling the previous cases. So it goes to show the value of concurring and even dissenting opinions, because something that was not sufficient to change the court's mind 40 years earlier, 40 years later, the court basically dusted it off and said, yep, we're going to go with this now, and it's been the way ever since. Our final case in our series of cases that we must read to understand the Julian Assange situation is New York Times Company versus United States, better known by its nickname as the Pentagon Papers case. This is a case that was a landmark decision by the United States Supreme Court that held the New York Times and the Washington Post could publish classified information without risk of censorship or punishment. And it also has the distinction of being one of the fastest cases to ever be heard and decided by the United States Supreme Court, probably ever. The United States government challenged this by filing a suit for an injunction on June the 18th, 1971. And 12 days later, June the 30th, 1971, the United States Supreme Court rendered its decision saying that that injunction was invalid. They went from a trial to an appeal to being heard by the United States Supreme Court to a decision by the United States Supreme Court, all in under 2 weeks. So yes, the Supreme Court can ball when it really, really wants to. So not only did they rule in favor of being able to publish classified information, they put their foot down in order to make that decision. So with all that background in place, how does that relate, and how will this be decided as it relates to Julian Assange? And the short answer is, I don't know the answer to that question. Obviously, when you go after a reporter for publishing information, you have an obvious First Amendment challenge. In my view, not under freedom of press, but under freedom of speech. But either way, you have an interest in being able to make speech. The Espionage Act itself is written very, very broadly. So under the text of the Espionage Act, Julian Assange is probably guilty of the crime being charged, but then again, it's written very, very broadly for a reason. It's designed to capture a whole bunch of stuff, and it relies on discretion in terms of its enforcement. But even the broadest law must ultimately give way to the First Amendment. The First Amendment is a floor on this thing. The trial court is going to charge the jury that hears this case based on the law as it currently reads. And the law as it currently reads would suggest that Julian Assange should be convicted by the jury, assuming that they can prove the facts and evidence, which it seems likely they can based on everything that we know based on the public record. With their conviction in place, the really, really interesting and fun parts are going to be in the appeals process, where the Fourth Circuit, because this is the District Court of Virginia, will have to be appealed to the Fourth Circuit. And then almost certainly the United States Supreme Court are going to have to get involved with the really, really tricky and fun legal issues about where the First Amendment stops and where the Espionage Acts can begin. I do not believe that Julian Assange is a member of the press. Then again, I don't believe that anyone is a member of the press. I've discussed this in an earlier video. But fortunately for Julian Assange, in my constitutional interpretation, he doesn't need freedom of the press to protect him. The interest here is freedom of speech, not freedom of press in my view. And the freedom of speech interest is the one that would ultimately be, in my legal opinion, the one that would carry the day. In my view, in this particular context, what he did was protected by First Amendment grounds. But it is an untested area of law, and it is something the Supreme Court is going to have to look at. And there might be issues that stretch the boundaries of what the First Amendment protects when we really, really get into the deep legal levels. But on surface level, I think counts 1 through 17 are facing a legal uphill battle. Count 18 is a much clearer case from the United States point of view. Conspiracy to commit computer intrusion, that seems perfectly reasonable. When a person breaks into a computer network or hacks, that's illegal. And if you conspire with them, in other words, you agree with them and perform some overt act, give them aid, give them assistance, give them direction, that's conspiracy. And so you can be held liable the same as you can your conspirator, because that's how conspiracy law works. So I think count 18 does not suffer from any obvious constitutional problems. Obviously, they still have to prove the underlying facts, which is ironically a little bit harder than it is in counts 1 through 17, because 1 through 17 deals with WikiLeaks publications, which is, as it were, on the public record. Count 18 deals with whether Julian Assange provided assistance or directed or otherwise tried to assist Manning in terms of gaining access to this computer. And I don't know enough based on the public records facts to say that Julian Assange is clearly guilty of the crime. It's not enough in the public record for me to make that kind of analysis. So counts 1 through 17, factually clear, legally questionable. Count 18, legally clear, factually questionable. I don't know whether or not the United States really intends to go forward with this indictment or not. Julian Assange is still overseas, so this could be part of a tactic of providing enough criminal charges as part of getting him over here as an extradition. So maybe this is just purely for those purposes and they don't intend to go through, or maybe they do intend to go through, but to get some information that will be helpful in some other context. If they ultimately go all the way through this and they ultimately get a conviction and ultimately go to appeal on legal issues, well, 3 judges somewhere in the Fourth Circuit are going to have to think really, really hard about the most complex questions of the interaction of First Amendment law, right to know, and the ability for governments to keep just secrets. I also don't think that there's any complication in terms of Manning's liability. Manning's liability in terms of handing information to Assange, that's clearly not a problem in terms of criminal law. But to the best of my knowledge, Manning has already been charged with, convicted of, and pardoned for all those related crimes. So I don't think there's anything new for Manning to be charged with here. And they certainly haven't brought a new indictment against Manning relating to this. All in all, this is some of the most complicated legal questions we have. It goes to values that we face as a society. It goes to when should the government be able to keep secrets? When should people be able to speak freely? What does freedom of speech mean? And if there's anyone out there who says this is really, really simple because the First Amendment says Congress shall make no law, well, I don't know what to tell you. You and I are going to have words because there's about 80 years of case law that very clearly explains the first limits of the First Amendment. It's not that simple. So anyone who's trying to make this reductionistly simple, I think is probably missing the boat. For now, my friends, that is all. I hope this overview has been helpful. Until later, cheers and goodbye.